Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for over a decade. You can find me on all social platforms at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, September 17th, 2025. In this week's episode, terrorism charges are dismissed against suspected CEO shooter Luigi Mangione. Plus, a man facing the death penalty for the murder of his pregnant mistress. But first, prosecutors announced charges against the accused assassin of Charlie Kirk. Today, we're joined by Rich Schoenstein, an attorney and legal analyst you can catch on Law and Crime Network, Court TV, News Nation, and many, many other outlets. Rich, welcome. How are you, my friend?
I'm well. Good to see you, Josh. Slow news week, so
yeah, right.
We'll try to slog through this, huh?
Yeah, we'll try to find something interesting to talk about in all of this. I'm so glad that I know how busy you are, aside from covering all these cases. So I'm appreciative of your time with us, and I always love hearing your thoughts because I think you have such unique insights, and especially in one of the cases today is out of New York. So I'm going to really call upon your expertise in that case. But before we get to that, let's first go to Utah County, Utah, where police have formally charged a Utah man in the assassination of Charlie Kirk less than 1 week after the fatal shooting. Tyler Robinson faces 7 criminal counts in the conservative activist slaying, which prosecutors indicate they intend to seek the death penalty against the alleged gunman. Kirk's shooting, which unfolded at a speaking engagement at Utah Valley University, dominated headlines and social media with speculation about the shooter's identity and motives spreading rampantly. Robinson was eventually turned in by his own parents, who allegedly recognized him from images released by police. According to authorities, Robinson also disclosed a potential motive to his parents, saying, quote, "There is too much evil, and the guy," speaking of Kirk, "spreads too much hate." Robinson also allegedly disclosed his actions in a Discord chat, and the FBI announced that they are investigating more than 20 members of the chat to determine what the individuals knew prior to the shooting. It doesn't appear that Robinson has obtained representation as of the time of this recording, but his next court date is scheduled for September 29th. All right, Rich, this is a case that obviously has the entire nation watching. It's an incredibly disturbing and heartbreaking case. But I wanted to talk to you about, we've learned a lot in the last few days, especially during that press conference given by the DA there in Utah. Was there anything, I'll just let you jump in, was there anything that stood out to you in particular?
So I'll start by acknowledging that he is innocent until proven guilty. He is entitled to the presumption of innocence, just like everybody else in the system in this country. The evidence against him, as it has been described, is staggering.
Yeah.
You have a confession potentially to his parents. You have written confessions on text messages to his friend or lover. I'm not exactly sure how to characterize that person, but you have written, and they're fully written out. They're not in code. They're not in gamer chat. They're like in full sentences with punctuation,
right,
without acknowledging that he did it. We're hearing DNA evidence on the gun. You have the gun, of course. And you have other physical evidence against him. That they say they got a palm print. I assume they're going to match that. Other DNA evidence that puts him at the scene of the crime, which is the roof of a building. So that all seems pretty overwhelming if it's true.
Yeah, no, I agree with you. And I appreciate you saying we are still talking about allegations, but it was a fascinating press conference to me because usually you do not see the DA kind of lay out their case. And I think they wanted the public to know that they definitely have a strong case to begin with against this man. And they outlined everything you just said, including that text exchange, which was notable to me because of how much it described. If my understanding is correct, the text is obviously before he's apprehended, but even before certain information was disclosed to the public concerning where the rifle was located by police, the inscriptions that were written on bullets, and he's referring to these things in these text exchanges, which to me is, this is now a person with inside knowledge of how this crime was committed and essentially saying, yeah, I did it. Really damaging stuff, which brings me to my next point here. I know this is so early on, but what does the defense start to do? How are they going to start crafting a defense at this point?
Yeah. So, by the way, I want to say one thing about the confession. When you think about confessions, you want to know, did the person actually make it? Was it voluntary?
Yeah.
And is it at all ambiguous? Okay, let's talk about the defense. Again, if all of this is true, right? I mean, if they have an alibi, they would put on an alibi. If the DNA doesn't match, then they'll put on DNA experts. All of that stuff. If someone broke into his email and texting and sent those confessions on his behalf, he'll put on that. But let's assume none of that is true. Then to me, the task of a defense lawyer is to keep him alive. Yeah. Right? You don't have a path to freedom. You don't have a path to an acquittal, really. You're not getting jury nullification, even if there are some people out there who didn't like, or many people who didn't like Charlie Kirk. So your only goal here is to avoid the death penalty. And the two ways you do that are either you try to negotiate it out of the death penalty, or you try to put on a case at trial to avoid the death penalty.
Yeah, I agree with you. In fact, I would not be surprised. And again, this is so early on. We don't know how things are going to change. We don't know what challenges to warrants and everything else there might take place. But assuming all the evidence we've heard, plus some, ends up at trial, I wouldn't even be surprised if it was one of those cases where they go into the guilt phase of the trial, if they're not able to negotiate a plea, and just kind of do he did it, ladies and gentlemen. We're here to say he did it. We're asking for you to wait till the end, where we have arguments to talk to you about when they get into the penalty phase, to kind of save some credibility with the jury, and then just like you said, beg to spare his life. But we're putting the cart before the horse a little bit, as it were. Let's stick to what we know right now. One of the things that was surprising to me is how many people he may have been talking to. And I'm not all that familiar with Discord. Maybe you are, but it sounds like he was chatting, according to the FBI director, Patel, with far more than 20 people, and may have been discussing his plans. We've not heard that yet, but if he was, were you surprised that there were no discussions during that press conference about conspiracy charges or other people being involved?
I wouldn't be surprised if there was no discussion. If they're looking at other people, they're not going to talk about that at a press conference. Why would you?
Right.
You don't alert those people. So if there is something there on Discord, if there's a possibility that somebody else encouraged him, incited him, or assisted him in some way, then they're going to look at that and try to find those people and deal with it. And they're not going to tell you in advance that that's happening. I'm sure that Discord chat, and I still write on a typewriter. I mean, I don't use that stuff. So I don't know about it that well. I'm sure that they are going through every last post to see where it leads.
Yeah. And that kind of dovetails into my next question, which I've been asked quite a bit about this, but everybody wants to know, are the feds going to jump in? Can they jump in? Under what theory would they be able to jump in? What are your thoughts on all of that?
Well, the feds could jump in. I mean, they could, I guess, try to bring federal murder charges, although this case, compared to the next one we're going to talk about, where someone crossed state lines to commit a murder, this one doesn't check that box of crossing state lines. Also, Utah is a death penalty state, so there's not necessarily a reason for the federal government to do it. But if it expanded into some sort of interstate conspiracy, by way of just making up an example, then yeah, that's a federal government. That is classic federal government topic, and they would look at it.
Yeah. And I think that's why they've been so, at least from, like I said, the FBI director has been so vocal about their interests in the people he was talking to over Discord. Because if there are people outside of the state, outside of the country, that would certainly open up an avenue for federal jurisdiction. But I think you and I feel the same, that most people watching this are saying to themselves, why? Why would they need to when the state of Utah is perfectly qualified and has the death penalty and has already indicated, even this early on, that they intend to seek it? So, like I said, a case I imagine we are going to be talking about for some period of time. It is a tragic, tragic case, and obviously affects our entire nationwide community, and we will continue to follow it.
Covering true crime for a living means that I've heard it all. Stories of break-ins happening in the middle of the night, burglaries while people are at work, even cases where the victims were home when it happened. It's one thing to tell these stories. It's another to imagine them happening to you. That's why I'm so glad my house is protected by Simply Safe. Simply Safe isn't just about reacting when something goes wrong. With Active Guard outdoor protection, it can actually stop crime before it happens. Their AI-powered cameras alert monitoring agents the moment someone suspicious approaches. Agents can talk with them in real time, trigger alarms and spotlights, and call for police before the intruder even gets inside. I love how I can manage everything from the Simply Safe app, arming the system, checking camera feeds, and getting alerts no matter where I am. Plus, you can add smoke and CO2 detectors to protect your home and family from more than just intruders. No long-term contracts. Plans start at about $1 a day, and they've been named Best Home Security System by U.S. News and World Report 5 years straight. Save 50% on your Simply Safe security system when you sign up for a professional monitoring plan and get your first month free. Visit simplysafe.com/truecrime to customize yours. There's no safe like Simply Safe.
Let's move to St. Lucie County, Florida, where a man is facing the death penalty for the murder of his pregnant mistress after she allegedly refused an abortion. Prosecutors allege that Jose Antonio Soto-Escalera was the father of Tania Wise's unborn child when the 8.5 months pregnant mother was found dead in a drainage ditch. Soto-Escalera, who was married at the time, allegedly gave money to Wise for an abortion, and prosecutors claimed that he was angered when she kept the money and moved forward with the pregnancy. Wise suffered blunt force trauma, which fractured her skull, along with a cut across her neck, which severed her jugular vein before nearly reaching her spinal cord. The victim's mother told jurors that Wise was excited about the prospect of her second child, who she had already named Josiah, and examiners determined that the baby was fully formed and would have been delivered healthy if not for Wise's tragic death. Soto-Escalera's trial is ongoing, and we will continue to update you as it progresses. Rich, this is a rough one for anyone to even consider, but particularly from the perspective of the attorneys trying to mount a defense on this person's behalf. So I'm going to ask you to kind of put on their hat for a moment. It's highly disturbing circumstances. The emotional impact of this case, I imagine, with jurors has got to be tremendous. What do attorneys do in that situation? I'm not even talking about this case entirely specifically, but just cases where it's just so horrific. How do you approach that?
Well, the first thing you do is you hearken back to what I said earlier, that everybody's presumed innocent. And the state has a burden of proof before it can convict somebody. And part of the duty of a defense lawyer is to test that burden of proof and to make sure the prosecution meets their job. And we have to do that in every single case for the system to work. So the defense lawyer always thinks they are doing, and they are doing, important work by testing that proof, making sure that the government comes forward with sufficient admissible proof to lead to a conviction, all the more in a case like this where, if found guilty, he potentially faces the death penalty or, at a minimum, is never going to see the light of day again. So that's what you're trying to do. And in the first instance, you are putting the prosecution to the test. What evidence you have on your behalf as a defense, again, varies from case to case. I don't really know what they're going to try to do in this case. I don't know if they're holding any cards at all or if they're just playing defense.
No. Talk to us about, we've already kind of referenced it in the prior case that we discussed, but talk to us about the penalty phase of a death penalty case. What kind of evidence can that include from the defense perspective? We know from prosecutors, they're going to go back through, how horrific the crime was. They're going to go through maybe criminal history that person had. But what is the defense? What opportunities do they have?
So most states have aggravating and mitigating factors that a jury has to consider when thinking about the death penalty. Aggravating factors are things like risk of harm to others. So we were talking about the Charlie Kirk situation. If you're firing into a crowd, you're putting a lot of people at risk. That is risk to others. Being a particularly heinous or cruel crime, which I think slitting the throat of a pregnant woman might qualify at, would be another aggravating factor. But each state will have a list of aggravating factors and may also permit that you can have non-enumerated aggravating factors. Most of the laws that I'm familiar with say the defense can present mitigating factors really without limitation. You can present anything you want as a mitigating factor. So what do people present? The defendant was young. The defendant was misled. The defendant was influenced. The defendant had a motive that isn't as bad as other motives. I don't know what that might be. Heat of passion can kind of be a mitigating factor, I guess, although that also goes to what level of murder you're being convicted for in the first place. So there are all of these things that you can present as a mitigating factor. But I got to tell you, she took my money and didn't get an abortion is not much of a mitigating factor.
Yeah.
I don't, how is that going to work to a jury?
Yeah. Yeah. It's awful stuff. I mean, again, just to take a moment to think about the idea that a woman who is essentially ready to give birth was beat over the head and then had her head nearly cut off and then left in a drainage ditch. I mean, it just doesn't get more horrific when those jurors start to think about that situation. Go ahead.
I gather the defense is trying to make some noise with the possibility that it wasn't really his child, or he didn't think it was really his child. He thought he was being misled about that.
Mm. Yeah,
that would be more effective to me with a less violent murder.
Yeah, you're absolutely right. Yeah, the circumstances of the murder itself, too, are just kind of hard to get around. I've worked on a couple of death penalty cases, and I will say it is kind of a remarkable shift when you go from the really kind of rigid, rule-oriented presentation of evidence during a guilt phase, and then you get into the penalty phase, and it's kind of like you said, it's like open game. It's just anybody, you've got, family members coming in and crying on the stand and on both sides. And you've got, the defendant's grade school teacher saying what a great guy he was when he was 12. It's just kind of this bizarre circus environment with just really playing upon the motions of jurors. So I imagine, given the evidence in this case, it will go to a penalty, and we will keep a close eye on it. Again, another very disturbing case. Let's leave it there for now and turn to our final case out of New York. And this is the one I'm most curious to hear your thoughts on. A judge dismissed terrorism charges facing Luigi Mangione, the alleged shooter of the UnitedHealthcare CEO Brian Thompson, which could lower Mangione's exposure dramatically. In a ruling, Judge Gregory Caro determined that the killing could not be deemed an act of terrorism, even if the alleged murder was motivated by ideology. Specifically, Caro opined that it could not be proven that Mangione's goal was to, quote, intimidate or coerce a civilian population, and said there was insufficient evidence that the killing was an attempt to influence or affect government policy by intimidation. This was a huge loss for prosecutors who theorized that the 2024 killing of Thompson was intended to evoke terror. Mangione will still face a second-degree murder charge, though the terrorism element will be removed. However, Mangione is also facing a federal death penalty prosecution, which his defense has argued violates double jeopardy protections, but that argument was rejected. Mangione is due back in court on December 1st for the state case and will appear in federal court days later. In the meantime, he remains behind bars without bail. Explain for listeners, how does this work in New York? At what point are we in the case that allowed the judge to make this kind of a dramatic, impactful decision?
So we're in these pretrial proceedings. He was indicted under state law, and the defense filed what the judge referred to as an omnibus motion, seeking Huntley, Mapp, and Mosley hearings. Those have to do with the admissibility of supposed comments he made, the admissibility of evidence that was found, like his backpack, and admissibility, I think, of some video evidence. And those can lead to the kind of pretrial hearings we see sometimes where the evidence is displayed for the judge out of the presence of the jury, and any argument is made about, for example, was the confession obtained legally. The defense also moved to dismiss the terrorism charges as legally insufficient and moved to dismiss the indictment for alleged violations of double jeopardy, arguing that they couldn't pursue the state and federal case. And the judge decided to consider all of that. I wasn't expecting him to dismiss the terrorism charges. I was surprised. I went on TV the day before and said I didn't think he was going to do that. And whoops, I'm not always right. So he did it. He put out this 12-page, well-written, well-reasoned decision, and he just took on the double jeopardy and the terrorism aspects of the case. So he granted the defense motion to dismiss the first-degree murder charges, and he denied the defense motion to dismiss on double jeopardy grounds, meaning both the state and federal case go forward. Now, just for a little context, right, a reminder or a refresher, New York state law, premeditated intentional murder is only second degree.
Right.
You need something extra to get you to first degree. For example, you kill a judge. That's extra. That gets you to first, or you're already convicted of a crime. That's extra. That gets you to first degree. The only thing they could have got to get Mangione to first degree was this terrorism aspect. And the reason the prosecutors were trying to do that is because first degree, you can put someone in prison for life without the possibility of parole, whereas second degree is always the possibility of parole. Last thing I'll say on that point, if you think about it, Mark David Chapman, who murdered John Lennon in 1980, he was convicted for second-degree murder. He was sentenced to 20 years to life with the opportunity for parole. It is 45 years later. He has not gotten out on parole, and I suspect won't. So it doesn't mean automatically that Luigi Mangione will see the light of day, but it is an important win for his team.
Yes. And I'm glad that you made that point. I feel like when people hear those numbers, 15 to life, 20 to life, they figure, oh my God, he's getting out in 15 years. No, it's a life sentence, right? But they get the opportunity to have parole, a potential for parole after a set amount of years. But in my view, this is a colossal win for the defense, because they were looking at a charge that would have landed him just on the state side of things, putting aside the federal side for a moment, life without parole, which is, I am sure the opportunity for a young man like him to have the potential of parole one day is a huge, huge win. And I'm glad to hear you say that you were surprised. I was shocked because I thought that the terrorism, and some people felt differently, that it was overreaching, but I felt that the terrorism charge here, though not traditional when we think of as terrorism, was certainly applicable and at least survivable of the judge making this type of decision. In other words, most judges, in my experience, would have left this up to a jury, saying, hey, this is a close call, but I think it's close enough for a jury to make that decision, not for me to take it even out of the hands of a jury. And that's what shocked me the most. But share your thoughts.
So I agree with you. And I also agree that I think there are a lot of commentators who are out there saying the opposite, that this was overcharging from the beginning, that this was foolish, that this is a bad stumble by the prosecution. You know, the judge said in his opinion, the court will note that the term terrorism has been famously difficult to define, right? It's famously difficult to define. We hearken back to the statutes in New York that talk about being intended to intimidate or coerce the civilian population, influence the policy of a unit of government, or affect the conduct of a unit of government. And the judge says he wasn't really trying, there's no proof he was trying to affect a unit of government or to terrorize the population. And to that, I say, then what was he doing? I thought there was enough to carry a terrorism charge. Yeah. And I agree with you totally. Let the jury decide. I mean, I leave open the possibility that a jury, especially since he apparently has fans, which I still can't believe, I leave open the possibility that a jury would have said, no, it's not terrorism, but that's who I feel should have decided it.
I completely agree. And I'm just, my mind is just kind of blown that this judge took this away from them. If somebody acting in this way, making a symbolic gesture through a murder is not committing an act of terrorism, I believe terrorism is famously difficult to define, but if anything, that would define it for me. But that's my soapbox and rant for the moment, and it does dramatically affect the case. Did you
go
ahead?
Thinking about that? So two things. Number one, it makes the state prosecution a lot easier.
Yeah.
Like your burden of proof has just dropped down significantly. And in a way, it's a blessing for the prosecutors. They don't have to deal with any of that. They just have to prove that he did it and he did it on purpose. And then their case is done and he did it with a firearm. It makes it a really easy case to prosecute. And the other thing is, it's only going to make the federal people more interested in pursuing this, right? Yeah. Because, and that one has the possibility of the death penalty. Yeah. So I'm interested to see how those two prosecutions, I had the feeling the state one was going to proceed ahead. Now I'm not too sure because the federal government and the administration seem to believe that this was reprehensible conduct that needed to be dealt with.
It's interesting, just to kind of go into the weeds on this one step further, when drawing parallels between Mangione and Robinson, in looking at the statutes both in New York and Utah, I was surprised that there isn't something more clear-cut on the books to address this kind of conduct. Like in Utah, the way that they were able to get to the death penalty in that case was through this theory that the murder was committed while putting the lives of other people in danger. In other words, there's not something on the books in Utah to say a targeted assassination of somebody based upon their First Amendment expression is eligible for aggravated murder. It was an entire very long statute, and only one clause in there seemed to fit the facts. And the same thing with Mangione. You're saying that this kind of a targeted attack on a person based merely on who they are, what they stand for, what they're saying, does not qualify for first-degree murder in New York. Those outcomes seem like they may not have been entirely contemplated by the respective state legislators.
Yeah, I think that people are probably going to think a little more about the New York statutory murder framework, even though it's been around a long time. And in New York, of course, we don't have the death penalty. And by the way, I'm no fan of the death penalty. Right. One of the arguments I have against the death penalty is that it's it completely depends on where you live, right? It's different from state to state. It's different state and federal. It's different in every trial. It's just arbitrarily applied, and you go for it here, you don't go for it there.
Right.
It's inequitably applied for the most part, although we're talking now about both white male defendants, so that's not as much of an issue. But the lack of consistency in the way we deal with it in this nation, on top of all the other arguments against the death penalty, puts me where I am on that issue.
Understood. And I don't think you're alone. I think a lot of people would, especially when we're talking about such a serious, the most ultimate of penalties, that there would be a little more consistency and clarity on the issue. But that's where we're going to leave it for this week, Rich. We can't figure out everybody's problems all in one episode, but I appreciate you coming on. Where can people find out more about you?
Sure. So I practice law in New York at the law firm Tarter, Krinsky and Drogan. We are a full-service law firm, main office in Manhattan, also Long Island, New Jersey. We have a Los Angeles office now, and we do a sort of general practice in all different areas: litigation,
Fantastic.
defense, matrimonial, all that stuff. On social media, I go by the name Lawful Riches, because that's easier to spell than Schoenstein.
And check it out. It's worth a follow. Rich has always got very interesting and clever insights, as was evident today. So thank you again, my friend. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, please check out my own YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts. And we would love to hear from you. If you've got questions or comments you would like us to address, please tweet us your question with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.